All right, hello everyone. Thank you for joining me for this brief pre-recorded lecture on knowing when to stop your research and basically how to organize. Researching can be, eventually, it's going to take time. I know in the beginning it's frustrating, but it can be really fun. And it's important that you know not only when to begin, but also when to stop and how to organize all of your research findings. So, how do we know where to begin, how to begin, and when to stop? Well, it depends. In terms of starting your research, you should always have a plan. One of the things I keep telling students over and over again, and it's even going to be on the final exam, is how do you begin your research? And the answer to that question is quite simple. You begin by brainstorming. You have to brainstorm for potential search terms. You need to have a plan in terms of when the deadline is. Make sure you have enough time to draft a good document. The best research in the world will mean nothing if you can't produce or communicate your findings effectively in writing. Make sure you're able to carve out enough time to do a professional job. If your name is on it, it should be your very best work, not a rush job. You don't want your name associated with crap, whether it's to your professors or a judge or a law firm. Make sure you know the jurisdiction. You also don't want to waste time on authorities that aren't going to be binding. So when it comes to potential search terms, think about any particular legal terms of art for that research area. Now, how do you know what the legal terms of art are for a particular area? Well, you need to look at secondary sources to get some context. Think about the different facts and legal elements that are involved. If you're starting in the books, it's a good idea to start broadly. If you're starting electronically, it's a good idea to be as narrow and as specific as possible. Think in general about the things or acts that are involved with the case that you're dealing with. The type of persons or places. Is this an employer-employee type of case? Is this a case dealing with an apartment complex or a prison system? What type of relief is sought? Do they want an injunction or do they want monetary damages? What procedure is being involved? What are the legal theories? Those are all things that can lead you to potential search terms. Now, a very important way to start your research would be the Case Digest. Remember, the whole purpose of the Case Digest is to try to look in a particular subject or jurisdiction and find cases. Remember, digests are organized by topics and jurisdiction. They're a very easy way to start and find some basic cases or figure out what your legal terms of art are going to be. In order to use the Case Digest, it's pretty simple. All you need to know are your search terms. Remember, a good place to go to would be the descriptive word index, not just to the digest. Once you find a good case or two, use those head notes to determine the topic and key numbers. And those topic and key numbers are like a map to lead you to additional cases. Another wonderful way to begin your research would be the annotated code. That works really well if you have a statutory problem or even a constitutional problem. Annotated codes help us locate cases that have actually interpreted statutes. So if I said, I want to see a recent case that talked about Title 42 U.S.C. subsection 2000, well, probably the easiest thing to do would be to look up that particular title and subsection number and look at the annotated code, because in every annotated code will be something called usually notes of decisions. And notes of decisions are little digest blurbs about cases that have talked about or mentioned the statutes that you're looking at. It's a great way to find cases that cite the statute. You can also locate secondary sources that are relevant and legislative history. So annotated codes are a wonderful place to begin. The only thing you need for an annotated code would be the citation. If you don't have an actual cite, then you need to start brainstorming for your search terms. Annotated codes always have an index. Some of them have a popular name index, and you may remember this from the previous pre-recording, but federal statutes tend to be named popular names like the Crime Victim Compensation Act. And so you can look up some of your statutes by popular names if you know what the name is. So this question comes up quite a bit, and I understand many students currently just are so used to doing things on the computer, they really don't see what's the point in spending time with print resources. Well, honestly, I try not to hide the ball. There are sometimes the electronic sources are going to be best, but there are also sometimes the print sources are going to be best as well. Let's start with the print sources. Print sources are best anytime you're dealing with a big book like a treatise or a horn book. So if you want to look at a secondary source that's a treatise on something or other, it's a lot easier to flip through pages so you won't miss something than to just jump around and try to navigate through a document that's thousands of pages on the computer. At least that's been my personal experience. Anytime you have law review articles or legal periodicals that are old, older than 1980, then it may be a good time. Anytime you don't know a whole lot about the topic. Remember, books are organized by subject, which allows you to do more broad search terms, and that will allow you to be more productive in print. So if you don't know much about the topic, you may be more happy using book or print sources before you go to electronic sources. Statutory research is very important to do in print sources. And I understand the tendency to want to just go to one particular statutory provision and be done. But when we're talking about statutory research, it's important to look at the whole statutory scheme. Is there an introductory section? Is there a definitional section? Are there exceptions? If you only go to one provision of the statute, these are important sections that you'll probably overlook. And procedural issues. So if you want to look at cases involving Rule 12b-6, well, you can do that pretty easily through a print source versus electronic. Now, electronic searching is great for recent articles like law review articles. Anything after 1980, electronic searching is totally the way to go. I would never try to update my research through Shepardizing, whether it's through Lexis's Shepards or Westlaw Keysight. I would never try to accomplish that in the books. It's just not worth it. Anytime you have unique, narrow search terms, which means you've already done your homework, you've already looked at secondary sources, you've already brainstormed, and you actually know what the legal terms of art are. If you have that information, then you should go ahead and do an electronic search because you will likely be productive. If you're dealing with a hot topic, some newer developing area that hasn't been dealt with before, you're going to be a lot more effective doing an electronic search. Finally, anytime you have a very specific, unique fact pattern, that's a good time to do an electronic search. It's important, whether, especially if you're doing book research, that you remember to update your research. So books can't be updated electronically, obviously. But many of you should have noticed when you're doing your library tours and our other assignments that some of the books had these soft cover pamphlets, or some of them in the very back would have more little thin paperback pages kind of shoved into the pockets. Those are called pocket parts. The way that you update research in the books is through looking at the pocket part or the soft cover supplement. Books can take a while to be published, but those pocket parts and soft cover supplements can be published in about a week's time. It's important that you always update your cases. Make sure you're dealing with good law by Shepardizing, whether you use Keysight or Shepards, doesn't matter. And this will also let you know if there are any new developments. Now, another place to begin your research would be secondary sources. Now, I actually think everyone should start here. But part of where you begin your research is really going to be based on what type of research you enjoy doing, your learning style, what you like. I love starting in secondary sources because I need context to understand information before I can digest it fully. I also love the fact that secondary sources does a lot of the heavy lifting for me. It's going to lead me to primary sources. It's going to summarize for me the most important cases on point, the statutes on point, whatever that's really relevant I need to know. A good secondary source should provide that information for me. It will also do a good job of identifying those key search terms and legal terms of art. Okay, so let's say you feel like you might be done with your research, but you're not sure when to stop. Well, it's going to take some practice. I wish I could say there's this magic thing that's going to come across your computer that says you can stop researching now, but it doesn't work that way. Even though there's sources that look relevant, it doesn't mean that you're done. It's always important to vary your approach. Don't just do the same research the same way, because of course you're going to get the same results. Try different avenues, look at different authorities, look at different publishers. If you've actually tried different avenues, looked at different publishers, thought of all the search terms and all of that, if you've done all you're supposed to do, then you may be ready to stop, but there's a big if you did everything you're supposed to do first. The truth is, there's always going to be one more case, one more article. So you've got to think about the value in your time and the whole diminishing returns. Is the additional research going to be worth the effort? And many students fail right here at this point. They think they can find that one more case and it's going to be worth giving up the day or two that they should spend on their analysis. And that is rarely the case. The best time to know when to stop is when you find an answer to the question. Now, in a really simple situation, if the question was something like, is a firearm a deadly weapon, you could cite the penal code in the state of Texas and you would be done. You have a definitive answer. But the truth is, it's pretty rare to have a definitive, clear-cut answer. A good rule of thumb in terms of when to stop researching is when your citations keep meeting each other again. So you're seeing the exact same authorities over and over again. But remember, this checkpoint only works if you've looked at various research methods. So if you did some research and you shepherdized and you say, hey, I keep seeing the same cases, well, of course you are. Your shepherdizing is only going to look at cases that have cited to the case that you shepherdized. That's not necessarily when to stop. But if you've tried some other methods and then you're seeing the same cases, then you may be at a stopping point. Most importantly, you know it's time to stop whenever there's still time left to report results in a well-written, well-reasoned, well-edited, and professional manner. You want to be proud of whatever you turn in, so make sure you have time to communicate your findings effectively. All right, so what do you do when you have just this big stack of stuff? Now, I am posting on Stanley an article on how to organize your research, and it has little charts and things, and it's really helpful when you have a big project and you've got a lot of cases and you're not sure what to do with them. Some people like note cards. Everyone organizes differently, but I'd like to give you a few tips. So I like to put things in stacks. The first stack will be secondary authority. Then I have my primary persuasive authority. Okay, so those are cases from other jurisdictions that for whatever reason I think may be helpful. And then I have my primary mandatory or binding authority for my jurisdiction. Now clearly I want to really focus on citing my primary mandatory authority. When I organize cases, I tend to write at the very front page quotation marks. That lets me know that in this case there's a great quote I want to use. Or I'll write a particular element, meaning that for this case really did a great job of describing this particular element. Or this case does a great job of talking about that counter argument. Whatever I'm trying to use the case for, I try to make a note about that fact on the very first page of the case. Otherwise, and I know from experience, you can drive yourself crazy digging through 10, 15, 20 cases because there's this great line and you just can't remember where you found it. When it comes to choosing cases, I understand you've done all this research and you want to prove to me that you read 100 cases to do this paper. Well, that's not always so impressive. I need you to use good judgment and make sure you choose the best cases, not just show me that you happen to look at a bunch of cases. Think about it this way. Why am I using a particular case? A good reason to use a particular case is because it talks about a rule of law or expresses a standard or factors well. It talks about public policy, or maybe it has a similar fact pattern. Those are all good reasons to use a case. When you have cases that kind of do all that, think about these general principles. First, higher authority really is better authority. If I had a trial level decision and I had something from the U.S. Supreme Court, yes, I will cite to the U.S. Supreme Court. You want to look for the highest authority and the most recent. Then you want to look for similar facts. Keep in mind, you may not have exact facts. In fact, that's probably going to be rare. But can you at least make an analogy? Also remember there's a hierarchy of authority. The federal system and the state system are independent of each other. If you have a federal problem, you want to start with the Supreme Court and the Court of Appeals in the circuit you're researching. So we're in the Fifth Circuit. So perhaps if I gave you a problem here, you'd try to focus in on, so let's say we're in a trial level court in the state of Texas in a federal courthouse, so the Southern District of Texas. Well, I would want to still cite Supreme Court cases and cases within the Fifth Circuit because those are the highest decisions that trial level court, even though it's a federal trial level court, would have to follow. State system is similar. You start with the highest court, look at the appellate courts in that district, other districts. Other states are not going to be binding, but they may be persuasive. Even if you have some cases in other districts, it can still be helpful. It may be highly persuasive, and at least more persuasive than something that's totally out of another state. A few caveats, though, when you're doing your research. First, you can cite dicta, but it's not binding. It can be persuasive. So if you cite it, you need to put in the citation that is dicta, or in your actual textual sentence. In dicta, the court said, blah, blah, blah. It's also important to note when we're dealing with diversity jurisdiction. So let's say you've got a citizen in Kansas and a citizen in Texas, and someone decides to sue in federal district court in the state of Texas. And let's say that Kansas law is actually controlling in this particular case. Well, anytime you're dealing with federal courts applying, state law, I said Kansas. Let me change that scenario. Let's say it's actually Texas law. Anytime you're dealing with federal courts applying state law, can you find some federal trial level decisions that have interpreted Texas state law? Yes, you can. And if you're actually practicing inside a federal courthouse, the federal judges will want to hear what any federal cases said about Texas law, even more so than a state Supreme Court case. So in that type of scenario, I would cite to that state's highest court, and I would cite to any federal cases that have applied state law. If, however, I was appearing before the state Supreme Court of Texas and there were some federal decisions that applied state law, I would have a different bias. My bias would be in favor of just state court decisions, not federal. So, all cases are not equal. One of the things you need to ask is if you're dealing with mandatory or persuasive precedent. So, one of the things I just told you earlier, state courts prefer state citations, federal courts prefer federal citations. You also want to know, what law governs. And this can be confusing when you look at State Digest because they will list both state and federal cases. When it comes to choosing cases, seminal cases are cases that show the beginning of the legal standard. This was maybe the first case that decided the issue or clarified the issue, what have you. Seminal cases can be really helpful to cite because they're so important. Everyone knows them, and they're the seminal case. Seminal cases may or may not be the best cases to use for your rule explanation. Remember, your overview and your thesis paragraphs are your opportunities to educate the reader about the law. So there's nothing wrong with citing a seminal case in the overview or thesis paragraph, but not discussing it in your rule explanation. Recent cases are important too. A recent case shows that the standard is good law. So if my seminal cases are from 18 whatever or 1942, it's also important for me to cite a recent case just to let the reader know that even though the law does develop over time, this is still good law. In terms of choosing the best cases, well, first of all, it's important that if there's a case that's really so important that it's repeated by everyone else, and that's usually a seminal case too, then the court needs to know about it, and the partner of the law firm needs to know about it. So you need to at least mention it in your analysis. Even though abstracts are really helpful to go through cases quickly, you still in the end have to read the case for yourself. Don't forget about stare decisis. Similar cases, similar facts, same jurisdiction. That's what you're looking for, essentially. There's also something called, what I call application cases. These are cases that basically allows you to apply the law to analogous facts. So any cases that are going to be really good for you to do that with, you want to make sure you consider those high priority cases as well. If you have done your research and you can't find any cases with any similar facts, then you want to go to the seminal case. You want to look at cases that have common broad themes. Maybe a case has a totally different fact pattern, but it did a really great job of explaining the legal rule, the factor, or the element. Anytime a case has been decided, usually that's not the end of the story. When you shepherdize a case and you determine if it's good law, sometimes subsequent history is important. For example, if a case has been affirmed on appeal, or if cert was granted, any of those type of important things on subsequent history, you need to let the reader know. So if I have a trial level decision and the Circuit Court of Appeals affirmed it, that's important subsequent history. So what do I cite to becomes the next question. Do I cite to the trial level decision that I originally relied upon, or do I cite to the Fifth Circuit case that affirmed my lower court decision? Well, the answer is it depends. First of all, because higher authority is better, my first goal would be to try to see if I could rely on the higher court decision. But sometimes the higher court doesn't even address that point of law, and in that case, you need to rely on the lower court decision. Also, sometimes the higher court may just say something like affirmed and not really give you that rich explanation or that analysis that the lower court decision does. You also want to figure out if that latter decision impacted the outcome or reasoning. Is there still an appeal pending? What if you shepherdize a case and you find out that it's been criticized? Well, you don't want to ignore a case just because it's been criticized. You want to know if there have been any later cases that have criticized the case fairly. If they've criticized the case fairly, maybe that could be a good counter-argument for you. Did the criticism come from other jurisdictions? Why were they so critical of your particular case? Or is it just one case that's critical? If a case in your jurisdiction is criticized by other cases in your jurisdiction, you really need to pay close attention. Is it possible that that case has been overruled? Has it been distinguished frequently, criticized significantly? Every now and then, judges just let out really awful opinions. Opinions that just aren't respected. They're constantly being criticized and distinguished. And you need to know going in if you're dealing with that type of case. Not all cases are published. Most of the courts of last resort, like most Supreme Courts, and I'm talking about state cases now, if that's the name of the court of last resort in that state, they publish most of their decisions. Intermediate appellate courts publish fewer decisions. Trial courts rarely publish, particularly in state level court. And finally, for unpublished cases, keep in mind that different courts have different local rules. In some jurisdictions, they'll clearly state that an unpublished decision should not even count as precedent, so you almost count it like a secondary source. Some jurisdictions prohibit you from citing it altogether. Some courts allow it, but only as persuasive precedent. Some judges will allow you to cite unpublished decisions, provided that you provide a copy to the other side and the court. So you really have to make sure you check out the local rules of court. So that is the end of our talk. Next, we're going to talk